Somali learner.
Yes.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Judge, on January 30th, 2025, officer ran a check on a vehicle in Harris County, Texas, without proof of financial responsibility. The vehicle also had a defective brake lamp. The traffic stop was initiated. Defendant driver, ID'd by Texas driver's license, stated she did not have insurance for the vehicle. Officer observed defendant to have thick
Bloodshot eyes or thick slurred speech.
And the odor of marijuana emitting from inside the vehicle.
Officer asked defendant when she last smoked inside the vehicle. Defendant stated she had a few roaches inside the vehicle. Probable cause search was conducted. Officer found 0.103 ounces of marijuana. A DRE officer arrived on scene and conducted Romberg test. Defendant estimated passing of 30 seconds and 12 seconds. Shows D is in an elevated state. DRE also observed thick SS, FSTS conducted 6.6 HGN, 3 out of 8 on walk and turn, 2 out of 4 on one-legged stand. When defendant was arrested, D repeated the phrase, "Oh my God," several hundred times. Officer knows from ARIDE training that this is a symptom of dissociative anesthetic. The SC read, D refused to sample the breath, blood, search warrant signed and executed.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Can you look to see if she has any prior DWIs? Number one. Number two, if she has a valid Texas driver license, please.
No prior DWIs.
Okay,
And your driver's license.
great. Okay. Ms. Lerner, like I said, no alcohol, no drugs. I'm going to randomly test you. Do you have the ability to hire a lawyer or would you like a court-appointed lawyer? Okay, I need you to fill out an application for me. I'll take a look at it. And then for now, I'll also have you sign a receipt with Victoria. I'll later have you get with Fleischer for your bond conditions and then I'll have you meet with a lawyer. In
Their license being suspended.
I'll let you talk to a lawyer about it. I can't give you legal advice. No, assuming we give you a lawyer, you can ask the lawyer and the lawyer can advise you properly.
I need to start working. I lost my job.
Just, yeah, talk to the lawyer and they'll be able to advise you properly. I haven't, as long as you have a valid Texas driver license and you have liability insurance, I'm not taking away your privilege to drive. Okay? So, yeah. All right, let me have you get with everybody and then we'll have you speak to someone here momentarily, okay? Sir, you were charged with the offense of assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
All right, on December 26, 2024, an officer was dispatched to a assault report. Officer made contact with the complainant witness who stated that her husband and her had been in a heated verbal exchange over her possibly having an affair. According to the complainant, the defendant was intoxicated and got angry when she began engaging in the argument about infidelity that were found on his cell phone. The complainant stated that the defendant then slapped her on both sides of her face multiple times, which caused pain to her head, and that she was also pushed to the ground, which resulted in her receiving an abrasion to her right knee. The complainant stated that she was able to stop the defendant from assaulting her further by using a baseball bat. The complainant had visible injuries to both sides of her face and her right knee.
Mr. Capetillo, I'm going to find that there's probable cause to go forward with your case. I am ordering you as a condition of your bond not to have any contact with the complaining witness in this case.
Can we address that, Your Honor? The state, we've spoken about this. The state reached out to complain and we're in agreement for no threatening, harassing contact. They have 4 kids together. She has no issue with him living in.
I just spoke with her and she wants him back home. So
Can I say something, Your Honor?
No, it's just now's not the time. Did she go to him with a baseball bat? Is that what you were saying?
judging the DIMS, it indicates that she had I'm not sure what she did with the baseball bat. She said, it says using a baseball bat to defend herself at the very end there. I'm not sure if we have
Scares me.
I'm not sure if we don't have an OR judge. That's all the facts that I have right now on that.
How long ago was this?
This was about 2 weeks ago.
And they're living together. He's, supporting his whole family. They have 4 kids together. He needs to be able to stay home, provide, and be able to help his wife with just taking care of his large family. No assaultive history, right? No assaultive history at all, Your Honor. One of his sons is also autistic, Your Honor, so they really do need help.
Mr. Capatillo, you are not to use, consume alcohol or illegal drugs, and I'm going to test you like crazy to make sure that you're not using. If I find that you use, I'm going to put you in jail. I will revoke your bond and I'm going to raise it up. Do you understand?
Yes, sir.
I will reluctantly allow you to have contact with this person, but I am ordering you not to have any threatening or harassing contact. You need to understand that what is threatening or harassing doesn't matter what you think it is. It's what the other person perceives. So if I go like this, is that threatening or harassing? It most certainly is, and it can land you in jail. Do you understand?
Yes, Your Honor.
I realize that times may be tough. I realize you may have stressful situations in this life, but you need to find some kind of outlet for it. Because if I find any other issues, I'm going to protect my community at all costs. Do you understand?
Yes, sir, I do.
And Your Honor, we're requesting a $500 PR bond.
I am entering what's called a magistrate's order for emergency protection that identifies her as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go. This comes with a residential restriction. I will take it off for now. But if I find there are any other issues, you know exactly what's going to happen. No consuming alcohol or illegal drugs from any source. Do you understand?
Yes, Your Honor.
What do you say? PR bond.
Judge, I don't believe that a PR bond is necessarily appropriate in this case based on the allegations and the fact that, the officer is indicating visible injuries to the complainant. We believe somewhere in the range of a $3,000 surety bond would be more appropriate.
Your Honor, my client's a U.S. citizen. He's taking care of his family. He's in court today. He has no kind of assaultive history. He has a good job. We feel that a PR bond would be appropriate at this time.
Any other prior assaults or assaultive history that you see?
Criminal history is from back in 2009. The last time he picked up anything, and it was a DWI.
Okay. Mr. Capatillo, I will give you a PR bond today, but I'm going to tell you, it's the only one that you get. If you pick up a new case, you start acting a fool out there in the free world, I will take the free world away from you, lickety split. You understand?
Yes, Your Honor.
All right. What did you say as far as the bond amount?
As for
3?
As for 500, Your Honor.
I request 3.
Okay, so I'll split it, 2,000. So you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games and not responding to phone calls, text messages, I will issue a warrant for your arrest. If you pick up a new case, violate any of the conditions, a warrant will be issued. Do you understand?
Yes, Your Honor.
If you ever have any questions, all you have to do is come back here and we can also answer any questions that you have, any issues that you may have, but don't just start doing stuff on your own.
Agreed, Your
We
Honor.
good?
Yes, sir.
Okay.
Thank you, Your Honor. Are you excused?
Yeah, but he can't leave until he signs.
Judge, did you need me to file anything on that one?
No, because he's going to be monitored because of the alcohol. Okay, you ready? Hi.
See you.
Been way too long.
Yeah.
Great to see
Many
you.
cases in here, Judge.
Okay.
This is Carlos Alfaro.
What do you want to do?
Well, does the court ever do dispositive suppression hearings, or do you run them as trial?
Yes. Yeah, but it's got to be dispositive. They got to be the okay.
Yeah.
If they give you the okay, I'm okay too. But I don't want to do a suppression. It gets denied and then we got to do it all over again. That's just, I've done it one time and just, so if they agree to dispositive,
We can agree to the plea, then I think that's the direction that we would like to go.
I know if you're thinking time served,
Well, or at least a probation on the first.
oh, yeah,
Okay,
of course.
okay,
Yeah,
all right.
absolutely.
Let's see if she'll agree to that, and if so, I'll set it.
Okay. Oh, you want to set it? Well, it's 190, so I'll give you a setting. It's not gonna be too terribly long. You're talking about
Yeah,
Alfaro,
set
right?
it for the hearing, if,
Oh, you mean for a dispositive?
yeah,
Got it.
okay,
Okay.
all right.
So I guess let me know. And then what was your second case?
That was it.
Oh, all right. Cool.
Easy enough. Thank you, Judge.
Ready?
Judge, may we approach? Judge, we're reapproaching on Mr. Evans Chan from yesterday. We rolled it to today so he can speak with his family to make sure he's going to post the bond. He will do that. We have a motion to withdraw the waiver.
Okay, done.
Oh, good to print out the reset.
And I think I've already admonished him, right?
We might
I don't
need to
think
do it again.
so.
Can we-
Let me print out the,
And then, Mr. Kim, did you see Mr. Doyle wanted to talk to you about Reader?
oh, yes, he's supposed to.
Or is Trevor here?
Emailed me. I'm still gathering information on that one. So he said he has to sign. All right. Make sure the date is correct on that one.
Looks like the 24th.
Fourth.
Is that about right?
Yes. Yes. I told Ricardo after I got back in my office an hour later, the DA called me, or ADA called me, and was like, actually, I'm not opposed to him getting a bond. Like, your sheriff's office told me up and down that you guys wanted to deny, like, do no bond under any circumstance. Like, yeah, they should really talk to us before. So,
You want to talk to me while we're waiting?
Sure. I have Ronald Waters on docket. Mr. Waters has a bond violation. He's not here today, but I spoke with him this morning. He says he could be here tomorrow. But I did study the violation report. He broke curfew twice on the 27th and the 30th. He said he got an apartment on the southwest side, which I verified with the address in the report that was sent. I studied the report. He's clearly on the bus. Looks like, I mean, I would say the report starts at his curfew 10. At that point, he's kind of like in the Herman Park area, but you can see each stop, and then he spends 20 minutes at the transit center, which there's no businesses around that. It's truly just the transit center. And then he goes west on the bus all the way to his apartment, on both violations. He gets home about an hour late, an hour and a half late, so.
He was working?
I don't have those details. I need to ask him, but he says he can be here tomorrow. I just don't want you to revoke him, Judge. He's here tomorrow. He's not anywhere that he's not supposed to be. He's constantly moving on that report on the way home. He said he just got that apartment, so he might just be trying to figure out how to make sure he.
It says here he got home at 11:45 PM.
I think it was 11 something. So the report starts at 10. He's constantly moving from 10 down the bus like route and into the transit.
Oh,
center.
so you really think he's on the bus the whole time?
I do. I mean, I don't know the actual bus stops, but every minute he's at a different location and it goes to the transit center, which I did look up, Google that address. And then it's constant stops all the way to his home.
Okay, I'm not gonna dig him because he's on a bus, right? I
Okay.
mean, what's he doing out that late? Why is he getting on the bus that late? I mean, what time does he get on the bus?
That's why I told him to come tomorrow, because I don't have the answers to those questions right now. But it's something he needs to work out, but I think it's
All right,
more so.
we'll roll this tomorrow, for sure. Yeah,
Thank you.
yes, ma'am. All right, this is Mr. Chang, right?
Sorry? Oh, yeah, that goes to, yeah.
So, good morning, Mr. Chan. So it looks like you have someone that's going to post your bond. Understand that we do this one time and we do this one time only. You know that actions have consequences, and if you fail to go turn yourself in by the time that we give you, I'm going to revoke the bond and I'm going to set it at 0, and that's it. Do you understand? So is there a bond set over there?
No, I don't believe, not until he self-surrenders, or until he's returned, sorry.
Okay, so once you do that, you got to let him know when you're going to do that, so we know to look it up. All right? Okay, good luck. Thanks.
They did.
Great. I still roll with them like crazy.
Okay.
Yeah, do well. What'd they say?
Oh, okay.
Oh, yeah. Well, when they're a baby, right? They have razor sharp teeth. And then so he would bite. I mean, my hands are all like just gnarly because they're razor sharp when they're little babies, right? So they just bite you and they tear your skin up.
Yeah.
Yeah.
She'll be back soon. She'll be back about a month and a half. She's been on the train.
Oh, really? Oh, congratulations. That's right. Is that number 2, right?
That's true, yeah.
Right. That's.
I'm retired. 3, right? 4. Wow. Respect.
I'd have more if I had more money. I got no money. So what they say? Are they is positive? Okay. So when do you want to do it?
Would we do it in an afternoon?
No. Mid-morning.
Okay. Well, I would just need, I guess if we would need a subpoena officers. I mean, I don't know if they're.
We would subpoena the.
Yeah, I mean, I guess it depends if you guys are gonna stipulate that it's a warrantless arrest. Because if you are, then, then the burden shifts to y'all.
Okay.
I don't care whatever date you want.
Okay.
It's okay with me. Doesn't matter.
Okay. Let me get one for me. Thanks, Judge.
I have Arizpe, ARIZPE.
Okay.
You read him his bond conditions when he was in custody.
I can look it up.
Just double checking, since he is here. No, it wouldn't have been you, it was a visiting judge.
It says, I signed something December 10th. The only thing it says is all conditions to be supervised by the state.
So that just means there's state bond conditions.
Oh, I see.
And we did file bond conditions on the 10th, Your Honor.
I file those orders whenever they come in with previous magistrate orders, and then do what
So yeah,
conditions, so there's no,
there's no content and no weapons. That's it,
Okay,
as far as I see.
okay, he is on the GPS monitor. He was actually held in custody like 3 extra days because they didn't have GPS monitors. So they wouldn't let him out until he got one. But I'm not
He
sure.
picked up the new case, the terroristic threat.
Yeah.
Okay.
So we want to leave that.
I don't know. I guess you're asking to take it off?
I am.
I don't remember anything about the case.
I know we had a long
Hey,
discussion about this
what
in
happened?
December.
On the case?
Terroristic threat. So on the terroristic threat, that's whenever the officers were dispatched to a residence, the stepmother of the defendant, the complainant, stated that the defendant was upset because he was owed money. The defendant told other members of the complainant's family that if they don't have his money by that night, he was going to kill them, as well as he was going to send his people to shoot them up.
Oh, and he went like this or something like that.
And then the defendant was seen by a member of the family walking with a pistol in his pocket. And that's what happened, Your Honor.
You want to reach out to the CWs
See,
and see how they've been, how he's been? And if,
Your Honor, see if there's any.
yeah, no issues.
Okay.
Yes, Judge, we'll reach out.
Thank you, Judge.
I just want to approach real quick on Miss Megan Fine. She's on the docket today, Judge.
Okay.
We are 99% finished with PTI. The only thing is she has the portable machine, but she didn't send in proof. She's trying to call the company to get proof over.
Okay.
And that's it. So I know you have to leave early, but if for some reason she can't do that, can we just get like a really short reset so that That's the only thing that's left that she needs to do.
You got
And
it.
it's actually done, I just need to get proof.
Yes.
That's it, thank you.
Approach quickly, Your Honor.
Hey.
Good morning, how are you? Happy New Year.
You too. How are you, man?
I'm doing well, how about yourself?
Um,
Look, I understand.
Drama.
I understand. Okay.
Tell me.
Early in the year. Jacob L. is on your docket this morning.
Is it with an E or?
It's with an L, with the letter L. His last name is like Lana Donsala or something like that, so, you know, I don't want to mispronounce it. I know his first name is Jacob, last name is.
I see it. Okay.
So, state offered him a pretrial diversion. He's done the anger management class. He just has not completed the effective decision-making class. I resent him the link this morning and told
Okay.
him I needed it done ASAP.
He's got until next Wednesday.
That's fine, Your Honor.
If he doesn't have it, I'm gonna carry him day for day until he gets it done.
Yes, Your Honor.
Okay.
Thank you, Your Honor. Have a great day.
May I press your honor?
Yes.
First kind of walkthrough, you have the PSR in
I
front of you.
see it. Capatillo?
Yes.
Got it. Okay. Do you mind bringing him up? Or hold on a second. Hold on. All right. You are Mr. Frank?
Yes, sir.
Good morning, Mr. Frank. Sir, you stand charged with the offense of evading arrest or detention. You are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 74 days in jail with credit for the 75 days that you've done. Understand that this will go on your record. It's going to be there for the rest of your life. You also need to understand, Mr. Frank, that this is an enhanceable offense. What that means is that if you pick up another one of these cases, you may very well be facing a felony charge years instead of days. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never change this. You still want to do this. How do you plead to the offense, sir? I'm going to find you guilty, sentence you to the agreement. The enhancement will be abandoned. Okay, good luck to you, sir. Thank you. Good morning, Ms. Murphy. Ma'am, you were charged with assault, bodily injury. You are facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 81 days in jail with credit for the 27 days that you've done. Is this how you understand it? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So it's done today, it's done forever. You still want to do this. How do you plead to the offense, ma'am? I'm going to find you guilty, sentence you to the agreement. Is this one enhanced? Do you know? Let's see. It's included in here, right?
It should be in the middle of the, they were typed it up right there.
It's true that you had a prior assault. Well, no, then you'd have to abandon it. Because that would make it a minimum of 90 days.
Yeah, they abandoned it.
Oh, they did abandon it. Okay, all right. Good luck to you, ma'am. Thanks. I didn't realize they abandoned it. Okay, you ready? Capatillo, come up. Good morning, sir. And we are here now due to Mr. Kabir having a bond violation. This is our third bond violation report that we have had. Our first bond violation. So I guess let me start up. Mr. Kabir is charged with driving while intoxicated. He was ordered as a condition of his bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
He currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
And so we put conditions on him. I can't. Please, Felicia.
The most recent ones, Judge, or there's been a few that we've amended over time.
What are the current conditions now?
The current conditions now are a hearing court every time the case is set on docket, no new law violations, install a IID device in the vehicle, no driving without permission of the court, no drugs, no alcohol. Applying to obtain a scram device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6th, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond violation. The defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event that occurred on January 16th of 2025 at 11:55 p.m. It was also confirmed by a scram analyst as well. Correct?
Yes, Judge.
Okay, so.
Yes, Your Honor. So, yes. So to begin with the first amended order for pretrial, so if the state wants a copy, I have a copy to show them, but sure. So Your Honor, just going to the very first order, as Your Honor just noted, usually agency fees are waived for that. However, the box on that for saying that the fees were waived, I believe were not checked on that. Further, Your Honor, the main purpose here for your determination of giving someone bond in the first place is to establish that they come back to court. So are they a flight risk? And then also, are they a danger to the community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I can call a witness to testify that, but I know that you
But that doesn't
are aware of
excuse you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that you can just?
No, Your Honor, I'm trying to contextualize this because we've been here two prior settings before. I know you've concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second, there was no indication of alcohol consumption or drug use during that time.
It wasn't working. How are we supposed to know?
And Your Honor, again, one of the two main points of determining what kind of bond, both the conditions and amount are, will they return to court and community safety? Here, my client who's being accused of DWI wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by Scram, but no one is here to testify on behalf of. Well, we can call that, Your Honor, but sure.
Judge, I spoke with the defense counsel today and he said that he was not requesting to have anybody come here to testify to the scram device.
We have Fleischer that can be called up as a witness to testify as to what happened with and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did that. So that's, yeah.
Please.
Yes, Your Honor, we would call pretrial services, Ms. Felicia Charles.
Okay, ma'am, would you please come up, raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
So you have first amended order and then second, third amended pretrial supervisions and then the board.
So referencing the fourth amended order for pretrial supervision and bond conditions, what I'm showing you, do you recognize this?
Yes.
Can you tell us what this is and what are the conditions that are checked?
These are,
Sorry, could you repeat what you just said?
sorry, I said I don't know if she needs that. It was an extra paper.
Okay, I just want it on the record.
Sorry.
That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new, law violations, install ignition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain, we do have a curfew of 9 PM to 6 AM, and then a SRAM device to be installed.
And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
Admitted as one.
So in this case regarding the SRAM device, can you tell us about that?
Yes, so what exactly about?
What is that? What's the standard procedure someone's supposed to do?
Yeah, so a SRAM device is ordered and it tracks the press.
Objection, Your Honor. The foundation, I believe the state is trying to ask her to testify as far as are you trying to establish her as like an expert on SRAM?
And I was not trying to establish her as an expert, just from her experience, what the SRAM device is basically for, which she can testify to as a trial.
I'd ask that the court consider that as that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there is a violation for alcohol consumption. So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph.
And I'm showing her now what's marked as State's.
For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay, please.
Have the graphs been printed, State, or she's just referring? Yeah, just so we can all agree on what she's referring to.
And I'm showing you what we marked as State's Exhibit 6. Can you please tell us what this is?
So this is a SRAM report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per.
Okay, so this very accurately depicts a SRAM report and what it says it is.
Yes.
We will tender defense for any objections and know that this has been, is it correct to say this has been emailed to defense prior to this date?
Yes.
Defense proceeded, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the SRAM was not completed properly?
Yes, so the device seems to be fully functioning. And on January 17th, Friday, January 17th, the SRAM device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 AM on January 17th.
Say it again.
9:05 AM, January 17th, 0% TAC was reestablished for the dissipation of alcohol.
Okay, and for those dates, the ones that match on what I'm showing you is State's Exhibit 2, the bond violation report, can you please, do you recognize this?
Yes.
Can you please read the details of the violations here?
It says the defendant was ordered to obtain a SRAM device and to refrain from alcohol consumption and not tampering with the device. The defendant's SRAM device has reported one consumption event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 PM. This information was received on 1/17/2025 and confirmed by a SRAM analyst.
Thank you, we passed the witness.
Okay.
All right. Good morning. I just want to, if you could turn to, I believe it was it's Exhibit 3, I think, for the Scram non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay. Would you stay, since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
Yeah.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
So let me, sorry, that was a poorly phrased question.
I'm sorry,
No,
understand.
that's my fault. Don't worry about it. My question is, did she consult with you when compiling this report?
Would you be more specific?
Did you help in the assembly of this report?
No.
Okay. Have you ever assisted or aided in the assembly of a Scram systems non-compliance report?
No,
No, no one in the department does. Okay. And do you have any sort of, have you ever worked for Scram systems?
No.
Have you ever had any special training in Scram systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but not expertise.
Sure. And what exactly did this person teach you?
We went
Briefly.
through how to read the graph, kind of how to establish consumption versus a tamper, environmental factors versus consumption, et cetera.
Okay. So during that training, did you ever actually look at a physical device, the Scram device?
No.
So you didn't do any like live experiments where, like, for instance, you put on a Scram and then, drank alcohol to see how that works?
No.
No. Okay. And as far as Mr. Kabir's Scram device, have you examined it prior to this hearing?
Me personally, no.
Okay. And so, one second. So is it fair to say that you've been thoroughly trained on the theory of Scram device and alcohol detection? Is that fair to say? That let me rephrase that. So you don't have any actual technical experience with how the Scram device detects alcohol in someone's skin. Is that fair to say?
Thank you.
I don't want you to think. Is it yes or no?
I still don't understand.
I'm trying to understand too.
Do I not understand how a Scram device works, or have I not for myself? And
Sure. So, this is pretty, is it fair to say like the science is kind of advanced here? Like when you received your training, did you have the personal opinion that was advanced science that you were learning about?
I believe so.
Okay. And you don't, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I partially wrong about?
Yes, reading the graphs, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially, as well with tampers, environmental factors with that, makeup or placing something between the skin, how things are worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no withdraw that question. So I'm just saying there was no actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it, so we examined the report for that.
Well,
and also reviewed some of the
peer-reviewed articles.
Well, that's great. I'm glad that you want to, a lot of people won't. They'll just kind of do their jobs, right? I'm glad that you want to further knowledge, but what I'm trying to get at is it's fair to say that knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? You agree with that statement?
Yes.
Okay, so without actually having examined in your own personal observation how a scram device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Objection asked and answered.
Okay, just, let's go.
All right. Just ask the question. I don't know if that was an objection or sustained or overruled.
Let's just move on. I mean, we're here to see, is there a positive blow or not? She's testifying that there was.
Sure. I'm just saying that this, all right, I'll make my argument in closing. I don't have any further questions. Thank you.
Okay, closing, or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the scram device has been tampered with?
Yes, we get notified of tampers and consumption events.
And you get notifications if it's been cut off? Like, just what's been going on with the scram device? You get those notifications?
Yes.
Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a scram device and for refraining from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened January 16th of this year at 11:55 p.m. And this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated the order, was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be detected.
Okay.
Yeah, Your Honor, I agree with State insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that, Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say again.
These devices are used all the time.
Well, their use all the time is
Just so-
irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. it would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
Or we have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well?
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Here this week.
that wasn't, are we still on the record then? On the, okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself, on whether it tests cannabinoids, which Delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any delta whatever. Regardless, it's number 3, goes with you.